Hey guys, hope you all have had a good week. I did not expect to do a live, but if you haven't heard the news already, there is some bombshell, and I'm going to put that in quotations, not because I don't think it's bombshell information, but you might think it's nothing, and you can let me know. New filings happened today, too. So, from the defense side, filed by Trump's lawyer, we have an expert, a cell phone data extraction expert, looking at evidence from triangulation from AT&T cell phone records from Nathan Wade's phone. And he's going to tell us that, hey, there are some funny things happening with Nathan Wade's location in 2021 before he was appointed as special prosecutor. Things that are uncomfortably close to Fani Willis's condominium address. We're also going to have a response filing very quickly. It was also filed today by the DA, by Fani Willis's team, saying, hey, this expert is garbage. This isn't accurate. In fact, I was actually at other places during these times that they're saying the cell phone pings were near me. So we're going to look at both of those filings, and you can let me know what you think. I see Tracker's here, and Tracker did the homework, so Tracker always has a ton of insight. I am looking forward to what she says along the way. Now, we're going to jump right in first for the defense's motion. It's short, guys. It's only 8 pages. So again, this is being filed by Trump's attorney. President Trump hereby files as corrected proposed supplemental defense exhibit 38, and they mention here in a footnote that there's a correction because they actually wrote 12,000 text messages on the original filing when it should have been 12,000 interactions, which is kind of a big deal, right? 12,000 text messages sounds like a lot of back and forth, but interactions could have been an attempted call or anything else. So they're filing this motion, and it consists of an affidavit from defense investigator Charles Middlestat certifying the Cellhawk analysis and reports, which are attached to the affidavit as Exhibits A through C. The Cellhawk analysis and reports, as well as the certified AT&T records, have been provided electronically via a cloud folder link contained in the courtesy service email. Mr. Middlestat, the author of Exhibit 38, is available to testify at the court's convenience. So he will show up and attest to everything that you're going to read here and maybe divulge even more. If you want him to come to the court, he's going to do it, just so Scott McAfee knows. And then here's the affidavit from Charles himself. My name is Charles Middlestat. I'm 59 years of age. I am a criminal defense investigator working with attorney Steve Sadow and Jennifer Little in support of the defense of Donald J. Trump in this case. In conjunction with counsel of record for Michael Roman, on or around February 9th, 2024, I personally served a request for records upon AT&T's Subpoena Compliance Center. Now, what date is it right now? Because it's about to be the 24th, but it's still the 23rd. This was already filed and prepared in court this morning, and they subpoenaed AT&T on February 9th. That's fast, if you ask me, to get a turnaround on that and to be able to look at it, put it in a filing, and fire it off. So, personally serves a request for records upon AT&T on February 9th. The requested documents included voice, call, text history, as well as a specialized location data for AT&T number, presumably belonging to Nathan Wade. On the morning of February 15th, 2024, counsel received the response from AT&T. So it took them less than a week. AT&T responded in under 7 days with the information. So they send over an encrypted link to the requested records, and I was provided access to the zip file containing the response from AT&T. Following my review of the zip file, I confirmed that AT&T fully complied with the request, the bulk of which included records for the period January 1st, 2021 through November 30th, 2021. So they are targeting in, they're honing in on what happened in 2021. They go a little bit over when Nathan Wade was appointed special prosecutor in the beginning of November. But mostly they're looking for that time period leading up to the appointment. The certified records from AT&T are included in the cloud folder titled AT&T Records, which is being contemporaneously served upon all parties. Upon receipt, I began an analysis using a Leeds online analytics tool called Cellhawk. Cellhawk is considered by law enforcement to be the gold standard, and to me, guys, gold standard's kind of like a buzzword that people will say, but they're saying it's the gold standard, and I don't know any better. So, Cellhawk, gold standard in cell phone records and analytics. It is used throughout the United States and Georgia by law enforcement agencies and should be well known to the Fulton County District Attorney's Office. Hey, so that's kind of good, right? Your DAs use this, so it must be good, right? As a board-certified criminal defense investigator, having specialized in criminal cases for over 25 years, I routinely use Cellhawk to conduct analysis on records, both uninitiated subpoenas and those received on discovery. My firm was granted a license and completed training in 2019. He's kind of young, or his firm's kind of young. I pay an annual licensing fee, and Cellhawk is the program I use exclusively to analyze such records. Since that time, my staff and I continuously attend webinars and remain up to date on training and the latest features available with Cellhawk Analytics. I have a strong working knowledge. Okay, so he's saying he's qualified. This is not the T. Let's go to the T. Now, a cornerstone of the Cellhawk Analytics tool is and it's italicized for emphasis, inability to manipulate the data. So he's saying that when you use Cellhawk, you should have the confidence that this data cannot be manipulated, at least not within Cellhawk. Data is uploaded as received by the cell phone provider custodian. Once loaded, it can be queried and examined in innumerable ways. From there, data reports can be generated using filters, and the geolocation data can be displayed in unlimited ways, including via an animated map. Under normal circumstances, analysis is conducted on data involving far narrower record periods, perhaps a few days or even a few weeks. It is difficult to understate the amount of data in this scenario, however. So basically, they're saying we're looking at all of this stuff from January 1st through November 30th. We typically look at a much narrower time frame. This is a huge file, but we're going to do it. While the sheer size in no way impacts the ability to conduct the analysis, it did require a different approach in order to narrow down potential dates to explore. I began my analysis by focusing on 2 distinct reports. So this is basically, he's telling us his approach to how he came up with this analysis, starting with the data he received on February 15th, and went through this in time for this affidavit to be prepared and attached in a filing today. So one is generating a report, attached as Exhibit A, isolating all interactions. This includes voice calls and text messages between Mr. Wade and Ms. Willis during the period of available records in 2021. The dates, timing, frequency, and duration of these interactions are included as part of that report. The report revealed over 2,000 voice calls and just under 12,000 interactions exchanged over the 11-month period in 2021. A heat map attached as Exhibit B highlights the interaction patterns which demonstrate a prevalence of calls made in the evening hours. So they're highlighting, hey, there seems to be a certain time of day where there's an affinity for these conversations, these phone calls between the two parties. 2, focusing on geolocation activity near, I don't know who's, maybe they'll tell us. Okay, so this is going to be the Yurdi condo. So the friend that had the condo and the interesting earrings. So 3300 Dogwood Drive in Georgia, which was testified to by Miss Yurdi as the address of her condominium, and generating a report to reflect such activity, attached as Exhibit C. Given the urgency associated with the need to analyze this newly acquired data against the relevant testimony, I constructed a very conservative geofence, which isolated the 2 cell towers in closest proximity to this address, one roughly 3,000 and the other 2,000 away. There's asterisks there, or is that how it's quoting? I wonder why. So 3,000 feet. Do you guys think that that's 3,000 feet away, 2,000 feet away? I wonder what their accuracy, can we pinpoint that he was within a square mile of where it's pinpointing between this triangulation? I'm not sure how precise this is going to get us, but I guess we'll find out. The purpose of this geofence was to conduct an initial assessment of whether Mr. Wade's phone ever connected to those towers. Additionally, this modality was used to eliminate the possibility that hits could be associated with routine travel on either I-75 or I-85. That's true, okay? Because there are some areas in not just Atlanta, but Georgia in general, where the roads suck. And if one accident happens, you could be sitting there for 2 hours not moving. So I feel like this guy is like, listen, we tried to make sure that whatever we're observing couldn't be attributed to traffic deadlocks. So routine travel on either I-75 or I-85, or visits to nearby attractions or the airport. Following that initial conservative sweep limited to those 2 towers, I finally constrained those findings to hits on Alpha Sector or Azimuth 2, which pointed directly at the Dogwood Drive community. Additionally, the report, and I wish they gave us more clarification there, because you're just saying which pointed directly at. But what exactly does that mean? That doesn't really tell us the precision, right? Additionally, the report was limited to those occasions when the phone was connected for an extended period. This conservative analysis, using the above reference modality, revealed a minimum of 35 occasions when Mr. Wade's phone connected for an extended period of time to either one of those towers in closest proximity to the Dogwood address. And that's based on associated data use, voice calls, or text messages. The data reveals he is stationary and not in transit. A deeper analysis of the data would reveal additional details, such as where his travel began or ended. For purposes of my analysis, I determined that his residence is located in East Cobb, and was able to review the records which demonstrate his phone pinging off the associated towers near his residence for consistent periods. So they're going to watch when he's at home at his own address after he may have been over at this condo that belonged to Mrs. Yurdy. Miss Yurdy? Because of the limitations in analyzing the sheer volume of data and preparing the report, I was directed to conduct a deeper analysis on 2 specific dates. So he's directed to conduct a deeper analysis on September 11th and 12th, 2021, before I understand Mr. Wade was hired, and November 29th through the 30th, 2021, prior to what I understand was the in-court testimony that the romantic relationship began in 2022. Specifically, on September 11th, 2021, Mr. Wade's phone left at the Doraville area, his phone left the Doraville area, and arrived within the geofence located at the Dogwood address at 10:45 p.m. The phone remained there until September 12th at 3:28 a.m., at which time the phone traveled directly to towers located in East Cobb, consistent with his routine pinging at his residence in that area. The phone arrived in East Cobb at approximately 4:05 a.m. So basically they're saying it gets to the condo where Yurdy says Fani was staying with her at 10:45 p.m., his phone is there. Nathan Wade's phone is at this condo where Fani was staying, and the friend said Nathan used to come visit until 3:28 a.m. And then it's not there anymore. And then approximately, 50 minutes later, 52 minutes later? Oh no, not 52 minutes later. About 37 minutes later, he's back home at his East Cobb address. And shortly after arriving home, 15 minutes after he arrives home, he sends a text message to Fani. So, what do you guys make of that? Is that a interesting timeline? Because they were asked, was he staying there? Was he laying his head there? And those answers seemed, they kind of tried to dance around those answers, both of them. In my opinion, I read it that way. Additionally, on November 29th, 2021, Mr. Wade's phone was pinging on the East Cobb Towers near his residence, and following a call from Miss Willis at 11:32 p.m., while the call continued, his phone left the East Cobb area just after midnight and arrived within the geofence location on the Dogwood address at 12:43 a.m. Now that's on November 30th because, we're crossing midnight. So we're starting November 29th at the end of the night, going over midnight. Now it's November 30th. The phone remained there until 4:55 a.m. The findings and data are presented in a PowerPoint presentation. According to Cellhawk, PowerPoint screen recordings are deemed to be the best way to present, in a transparent way, the totality of the data. So he's just explaining, if we do a demonstrative, that's how everything's going to be translated so you can view it, and it's actually recommended by Cellhawk to use that format. They do have some of the attached information here with greater detail, but let me catch up and see what you guys are saying. So Tracker says expert should be in quotes. And I asked, on X today, I'm like, what exactly makes an expert nowadays? Because it seems like it's something that people self-ascribe to themselves. Sometimes it doesn't really hold any weight anymore. It's like overused. And then, hey, Miranda. Hey, Blue. Okay, wait. Who the fuck? Okay, I've been hearing a lot about the Who the Fuck Did I Marry miniseries. I feel like I need to check that out. And then Miranda, AT&T was so quick. And then gold standard Trump style, meaning, so the sneakers, gold standard, those are the sneakers with the flag emblem, the gold ones. Oh, oops. Okay, so I think I can correct that right now. Let me go put the right link in the description so you can get both affidavits. I honestly think with Google, oh my gosh, every time I try to share a link from Google Drive, I have to check 3 or 4 times to make sure I make it visible for anyone that clicks it to actually be able to view it. It's a pain in the butt. And then let's go over to YouTube. That way, if you guys want to read these on your own, especially the affidavit, when we look at what the DA files in response, there's quite a lot of appendix items attached. So it might be helpful, instead of looking at it on a stream, you guys want to pull them up full size on your own device. Probably be a good one. And then we're talking, so No Lip Gloss says the traffic to and from Hapeville. Is it Hapeville? Am I pronouncing that right? Or is it like Hapeville? You know me and my pronunciations. I'm struggling not to say Fanny, because my eyes read it as Fanny and not Fani. But yeah, that's why I think that they knew, as an expert, they must be local. They must have been like, look, we have to make sure they're not just going to be able to think, hey, well, could it be a traffic jam that's making them sit in the same place for 3 hours? Because anyone in certain parts of Georgia would be like, that's totally possible. And then, see, I'm going to double check this link again. All right, so I opened it on my own. It is a different link now. So if you just want to give it a refresh in a second, because I think it has to save on my end, and then you can pull the proper response from Fani from the link in the description. Sorry about that. If there's ever a link that doesn't work in the description, just let me know. And then she didn't let her booty call spend that, right? That's, that's true. So it's at 4 a.m. you gotta go. But then again, he might have been going through the cancer treatment. Then, yeah, okay, so wait, 2021. But they were lonely, right? Because this is like, COVID had been happening for like a year. People were getting tired of being boarded up in their own house alone. So, maybe at that point, it doesn't even matter if the things are working. And then the title of the influencer, you're talking about being an expert, yeah. Okay. Hape like cape. Okay. See, that seems too easy, so then I gotta make it more difficult. All right, and then let's see. So now we've got some certification of cell record analytics from Cellhawk. So he's certifying here that this is accurate. Exhibit A is titled Wade Willis, Interactions for 2021, Data Report. And again, I want to underscore that we looked at 2 incidents specifically above. And this expert was directed to focus on those 2 dates of, Nathan Wade is arriving at like 10 and 11 p.m. and then leaving at 4 a.m. He was directed to look at those specific dates. So anyway, it documents all communications, texts, and calls between Nathan Wade and Fani Willis from January 1st to November 30th, 2021. Exhibit B, which is Wade Willis heat map, is a report reflecting the timing of interactions with prevalence of calls made in the evening hours. So we're going to see, I'm not actually sure, I didn't see that attached here, but I saw it published. I can go pull it up somewhere else. And then they're going to have a slideshow. So their slideshow is going to be, like, what, 44 slides? So basically, if the judge agrees to hear this, what's going to happen is Middlestat's going to go in there, and they're going to have this PowerPoint presentation. And they're going to look at the slides of all the data and everything like that. And they're going to look at this nice little heat map, which, let me pull that up because I thought it was pretty interesting, if I can find it. I should have saved it. Unless it was in Fani's. Did Fani respond to that? She also put it in her. Let's see. I don't know, there's a heat map somewhere, but it really just had warmer pink colors, like, it was like a fuchsia heat map, and it was darker around the evening hours, so, to me, that's kinda like if you're off work, when you start, like, checking your phone and having your conversations, that's when the activity starts to light up for most people that work, like, a 9 to 5 type of job. Not saying that they work 9 to 5 jobs, but, you know. Now this is gonna look like a lot. So Fani's response is way longer in page number, but if I scroll down and show you, a lot of it is just attached exhibits. Oh, so there is a heat map in here. Of course, the Zoom wants to be terrible, but you can see if this is like your 24-hour cell, starting with like right after midnight up here, and this would be midnight closing out the day. A lot of this is around that like 8 p.m. to 10 p.m. time frame where the biggest interactions, the more frequent interactions start taking place. So that's the heat map that was being referenced already. Oh, and they're referencing the tweet. That's why I thought I saw it in a tweet. So Fani is including this in her exhibit. So we're probably going to see her try to criticize or discredit this, or maybe complain that it was given out to the media because it wasn't in the corrected summary filing. So we'll see why Fani is the one that included this in her filing. But here, Citizen Free Press tweets this heat map and notes that there's 2,073 voice calls, 9,792 text messages, heavy concentration after hours, meaning like after work hours into the evening. And then it was happening 7 days a week. So it wasn't just limited to Monday through Friday, which might have been easy to explain by a Monday through Friday work communication need. So, but we're going to see, I'm sure we'll see why Fani included this and what she has to say about it. Let's go up here. And again, they had to have filed this quickly, because if this was just filed by Trump's attorneys, they have AT&T turn over these records, right? They're like, all right, for you, Trump attorney, we're going to get you these records super quick. Here you go. So they get that over. The guy does his work. He puts together a PowerPoint. They put together the affidavit to attach it and say, hey, judge, you should let us show you this stuff. And then quickly, the DA responds like, nope, and we're going to see what they say. So this is a state's objection to and motion to exclude defendant Donald John Trump's proposed supplemental exhibit 38, submitted in violation of a bunch of stuff in the courts, and they're bringing up daubers, so they're going to attack this expert witness. They're going to say he either wasn't properly credentialed or he's not, to the standard of qualifying as an expert to provide such analysis as understated. So that's going to be interesting. And the court's own standing case management order form for criminal cases. So they're going to say this goes against the court's own process for bringing evidence in. So comes now the state of Georgia, by and through Fulton County District Attorney Fani Willis, and both objects to and moves the court to exclude the defendant Donald John Trump's proposed supplemental exhibit 38, which has been improperly submitted to the court for consideration. The United States Supreme Court ruling on Daubert, and I'm really excited that they're going to cite that, because they're going to go bananas on this expert. And the court's own standing case management order for criminal cases. Supplemental Exhibit 38 contains both telephone records and have not been admitted into evidence, and an affidavit and other documents containing unqualified opinion evidence. For the reasons set forth below, the court must exclude defendant Trump's inadmissible proposed supplemental Exhibit 38 from consideration, or at a minimum, it must also consider the state's rebuttal evidence that demonstrates the unreliability of the unqualified opinion evidence improperly introduced by defendant Trump. So they're not just going to attack the data or the analytics or say, hey, this doesn't mean anything. They're also going to attack the expert witness. So let's see. So argument 1. Defendant Trump's proposed supplemental Exhibit 38 was improperly submitted in direct violation of court's own standing case management order for criminal cases and should not be considered. So they're saying this is not the process you're supposed to bring something like this in. While defendant Trump's proposed supplemental Exhibit 38 cleverly avoids the use of the term expert. Oh, so they're going to not try to use the word expert. They're going to hone in on that. It is clear that defendant Trump's submission is an attempt to have the court improperly received unqualified opinion evidence as written expert testimony. The court's own standing case management order for criminal cases states as follows. Now, this is important, right? Because then there would have to be a whole discovery timeliness. You're supposed to notify that you were going to introduce this. Did you properly notify the DA that you were submitting this to the court? Because if it's really an expert witness, if you called it an expert witness, you have to let your opposition, the opposing party, know that you're bringing that forward. And they just kind of dumped it today when the judge is supposed to be making some rulings. And so, I guess according to the court's own standing case management order for criminal cases states as follows. Experts. Any party seeking to rely on an expert testimony at trial or any evidentiary hearing must provide written notice to the opposing party. This notice must include a meaningful summary of the expert's testimony, as well as his or her qualifications to serve as an expert witness. This notice must be provided at least 14 days before the final plea trial calendar call and 7 days before any evidentiary hearing requiring expert testimony. Now, on one hand, the court could look at this and be like, yeah, that's true, but that means we'll just give you some extra time to look at it. But a judge could look at this and say, hey, we're going to get mad at the defense because you didn't follow this. Or we could say, hey, you only just had testimony on Thursday and Friday about these things that you've been trying to analyze. And we're actually surprised you got the subpoena responded to so quickly. But just please understand that we need to give the other side time to respond. Oh, the other side already responded quickly. So I'm not sure if the judge is going to be able to say that this had that much of an impact if the DA has already filed a thorough response. I don't know if the point I'm making makes sense. But they're not arguing here, hey, we need more time to respond to this. They've clearly been able to respond to it. And this judge seems to want to move things forward and is apologizing if things take 1 week to turn around, which is very fast for a judge, in my opinion. So I'm not sure if I think Judge Scott McAfee, is going to want to lean in favor of saying, yes, this should take longer than it is, unless you're inhibited from a proper response. That's just my take on Scott McAfee. So they go on to say further that the amended standing case management order for criminal cases on the 3rd of August 24th, at 3 August 24th, 2023, attaches Exhibit A. Defendant Trump's proposed supplemental Exhibit 38 violates this mandate of the court in 4 ways. They're going to bullet point it out. So 1, Defendant Trump provided no written notice to the state. That is a problem. I think that's a problem. Defendant Trump provided no summary of the purported expert's testimony. 3, Defendant Trump provided no information related to qualifications of the witness to serve as an expert witness. And 4, no notice was provided at least 7 days before the evidentiary hearing that began on February 15th, 2024. And this is why these 4 things that they're not doing, because Trump's attorney isn't calling this guy an expert witness, they're skirting around this process that you would have to follow to introduce any type of analysis or evidence or testimony from an expert witness. But they're getting around that by trying not to define him as an expert witness, Charles Middlestat. But the state's arguing here, even though he didn't use the word expert, they were very careful about that. It was very clever. It's essentially an expert witness, and this must be followed no matter what terminology they're using to characterize who this person is. They're asking to provide expert testimony through this guy. He's an expert witness, and this stuff should have been followed. So, it goes on. At the conclusion of the portion of the hearing held on February 16th, 2024, this was last week. This is not too long ago, guys. This is moving fast. We look at other stuff sometimes, even just even just in the Jonathan Majors trial, we saw how long it would take from one hearing to the next, and then the hearing would be 30 minutes long, nothing happened. Here, they're bullet point, bullet point, bullet point. They want to get this done before the election. So at the conclusion of the portion of the hearing held on February 16th, 2024, counsel for defendant Trump stated, "We are in the process of, if the court will allow us, to obtain certain phone records and we'd like the record kept open for the introduction of those phone records. We have them in draft informally. We do not have certification of them, and there's a footnote right there. So the statement by counsel for defendant Trump was untruthful. Okay, I love a juicy footnote. Defendant Trump's own proposed supplemental Exhibit 38 and the assertions of counsel for defendant Roman demonstrate defendant Trump had a business record certification in his possession on February 16th, 2024, and they're going to attach that as Exhibit B. So back up here, and they would deal with, if you'll remember, I asked Mr. Wade about certain activity in Hapeville during the time period, and it deals with that specific time period. We're talking about February or March of 2021 through November 1st. We would want to, if what we believe is there based on our preliminary research is there, we'd like to reopen and introduce records and someone to explain what they mean. So they note here that Judge Scott McAfee, 2/16/24 on the Roman motion hearing day 2, they cite a YouTube link. They put the YouTube link in there. Hold on, I want to see whose channel they're citing. The tracker probably already figured all this out, and I'm just like learning it on the fly. Oh, Judge Scott McAfee has his own channel, guys. Hold on. I'm gonna drop it in the chat. Everybody subscribe to Judge McAfee. Okay, and I see this comment, so Shahid just now while I'm trying to paste that in. So I'll get to the other comments too, but they are waiving Amanda rights instead of Miranda rights. All right, so they link to Judge Scott, and I wonder if that's actually Judge Scott McAfee. I like already switched out of the tab, but I wonder if that's actually his channel all the time, or if it belongs to that bench. Like maybe when he's no longer the judge, it gets passed on to the next judge. I wonder if it's his channel or the bench's channel. I didn't even like think that they did that. But I'm so used to looking at cases that aren't televised, right? So of course the judge and the bench or whoever won't have a YouTube channel to televise it. But shout out to them for the transparency. So they go on to quote something else at a different timestamp where counsel for defendant Roman also stated, as soon as we got a hearing, and that's Ashley Merchant. As soon as we got a hearing date and the state's response to what happened, when the state responded February 9th and admitted to their relationship, but put parameters on the timing, I sent subpoenas out in response to that. So Ashley Merchant saying, hey, look, as soon as we heard this, that's when we issued the subpoena. That's why the subpoenas were issued on February 9th. The problem is Delta, AT&T, and all these folks aren't super fast about all that. I know Delta were also waiting. I wanted to remind the court, waiting for those records to be submitted in camera. And AT&T actually emailed me these phone records yesterday morning on the way to court. Representations made by counsel for Donald Trump and defendant Roman make very clear to the court several relevant facts. 1. Defense counsel issued subpoenas for the telephone records at issue on or about February 9th. 2. Defense counsel had the subpoenaed telephone records in their possession at least as early as February 15th, 2024, and defense counsel always intended to attempt to introduce both the telephone records and an expert witness to, quote, to explain what they mean. In spite of this, defendant Trump made no effort to comply with the court's own standing case management order for criminal cases. Defendant Trump provided no written notice to the state in advance of the hearing, provided no summary of the testimony, and provided no information related to qualification to serve as an expert witness. The court's standing case management order for criminal cases was specifically intended to prevent parties from ambushing opposing counsel with purported expert evidence, without allowing opposing counsel a meaningful opportunity to review the evidence, review the purported expert's report and qualifications, and obtain its own expert in rebuttal. Now that last point is important, because unless they throw it in here somewhere, they're arguing these other 3 points, and I think the judge could look at this and be like, well, you're giving a 48-page response and then arguing that you didn't have time to respond. Maybe they'll make a more compelling argument about that. But again, if the judge is simply inclined to keep things moving at a faster pace, I think he needs something more convincing to be like, yeah, we need to give more time to allow all of this to play out. But I think this last part, we're short on time. We don't have the right opportunity to get our own expert as a rebuttal, to provide rebuttal testimony to this. So basically, unless they come up with having one in the rest of this affidavit here, this response here, it's a rebuttal without expert testimony to rebut it. That's kind of important, and I think a judge it could be a favorable ruling. He might agree with this argument here. Although, I guess that would only count if he agrees that Charles Middlestat is really supposed to be introduced as an expert witness. I think they're skirting the line. I think the defense is skirting the line there in not identifying him as an expert witness. But I'm not a judge, so the court cannot now allow defendant Trump to bypass this protective procedure when, in other cases, it has excluded expert evidence for a party's failure to follow the standing case management order for criminal cases. All right, cool. Are we going to see citations for these other cases? All parties coming before this court must be treated equally. Indeed, quote, treating like cases alike promotes a system of equal treatment under the law rather than one built on arbitrary discretion. So they're stating a Georgia case, which is quoting the Federalist from Alexander Hamilton. So I guess in this case, they must have quoted Hamilton, and this is the Hamilton quote, and they're quoting it through this case. So this case found an Alexander Hamilton quote relevant to whatever they were deciding. And then argument 2. We get to argument 2. Defendant Trump's proposed supplemental exhibit 38 was improperly submitted in direct violation of OCGA 24-7-701 and the United States Supreme Court's ruling in Dauber and cannot be considered by the court. So now we're going to get into expert witness stuff. Effective July 1st, 2022, the General Assembly revised longstanding Georgia evidence rules regarding lay and expert witness testimony by applying the provisions of we're going to just say 701, to criminal matters, substantially consistent with the standards set forth by the United States Supreme Court in Dauber. The provision shall apply in all proceedings, with limited exceptions that do not apply here. Defendant Trump now seeks to submit Supplemental Exhibit 38, which contains, among other things, an affidavit of witness Charles Middlestat that consists of opinions based on scientific, technical, and other specialized knowledge within the scope of 702. So this is not, they're saying this is not a layperson's testimony. A layperson, you or I, couldn't just jump up in there and be like, yeah, we can explain what all these numbers mean. Our opinions in here are like, hey, showing up at 11 p.m. and leaving by 3:55 a.m. Fani knows how to play the game. You get in, you get out. That's like a layperson. That's how we're commenting on it, right? But we wouldn't go in and be able to just like pop a heat map out of there, right? So that's the distinction they're making, and they're making that because a layperson having an opinion on something, there's a different process for an expert witness's opinion. And they're also trying to argue at the same time that not only should this person not qualify as an expert witness, but argument 1 was they didn't follow the process to tell us they were going to put forth this expert witness testimony. And then, hey, Pam, let me know if you want to jump in. I will send a link. And then, let's see. Oh, I think, so Miranda says, how did my name get mixed up in that? Was that because we were talking about Miranda rights? Sorry. I was reading that and I'm like, is someone in this filing named Miranda? Did I read right by it? Not even catch it? And yeah, in autocorrect, I have that pain. It always corrects my name to Matt, which is fine. Like, I'll know that you mean cat, but whatever. Let's see. All right. So we are back to this type of opinion testimony is specifically prohibited if a witness has not been qualified as an expert. No applicable exceptions exist under Georgia law. Prior to providing expert, and they're italicizing it. You see that, guys? Might be a little small for you guys, but it's italicized, the word expert. Opinion testimony. The court must make each of the following findings based on evidence in the record. So 1, the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact at an issue. And 1, I don't know what judge would sit up there and be like, no, that doesn't apply. This, whether you want to say he's not an expert witness, I think he's really an expert witness. He's clearly here to introduce some type of specialized knowledge to help the trier fact, which is Judge McAfee, look at the evidence and determine a fact in issue. And what is one of the facts in issue? Probably the fact in issue. The timeline of this relationship between Nathan Wade and Fani Willis, because they're like, no, it didn't start until after he was appointed special prosecutor. Didn't start till then. And the court isn't sure what to make of Nathan Wade's ex-law partner, who could possibly have a grievance, who likely has a grievance against Nathan Wade, coming out and being like, oh yeah, I knew about their relationship. They had a relationship. And then you have Yurdi, you have the friend that had the earring, saying like, yeah, she used to live at my condo, and Nathan Wade would come over there. And they definitely had a relationship before he was appointed a special prosecutor. So the judge has to decide, were Nathan Wade and Fani Willis, when they got up and said, that's not true. Our relationship, we didn't start doing this until after all that. The judge has to decide. He's the trier of fact in this case. This expert witness or non-expert witness, whatever, Charles Middlestat is there to help the judge decide this. One is absolutely a criteria that I don't think anyone could contest. 2, the testimony is based upon sufficient facts or data. And they're relying on data. We even had in the initial filing from the defense, hey, this data is so good. It's the best data. It's coming right from AT&T. The person at AT&T that handles subpoenas, this Hawkcell company, whatever it was called, is so good that they upload all of the data that was requested through the subpoena right to the software. So there's no chain of custody issue to worry about, because it doesn't come to us and then we do something with it and then put it in the software. It goes right from the person issuing the data in response to the request. They put it right in the program. So 2, we know we're working with facts and data, and there's no chain of custody issue to dispute that. 3, the testimony is the product of reliable principles and methods. And in the beginning of the first filing we looked at, I kind of skipped over it, but we had paragraphs and paragraphs of this is the principles that I'm using to do this. This is the process that the software recommends, and we followed it. This is the only software I use. So I've used it since my firm opened in 2019, and it's the only program we use. We use it all the time. I know how to use it well and use it right, and we keep doing the trainings, and we stay up to date. We use the right methods. So I don't know where there's room for the defense to contest criteria 3. And then 4, the expert has reliably applied the principles and methods to the facts of the case. And that whole filing was to a sworn affidavit from the guy saying, yeah, I did this reliably. I'm signing. So, based on this criteria, the party advancing the expert testimony has the burden of establishing its admissibility under 702B. Here, none of the required findings have been made by the court, and no timely competent evidence that complies with the court's standing case management order in criminal cases exists in the record that would establish even one of these factors, as our law requires. Indeed, Defendant Trump has provided no competent evidence whatsoever that would establish that Middlestat is in fact an expert in anything. Moreover, and they're going to get into lack of CV letter. Moreover, the telephone records at issue themselves, which form the basis of Middlestat's purported expert testimony, are not properly in evidence. No one has authenticated the telephone records at issue, and the certificate of authenticity of domestic records pursuant to Federal Rules of Evidence 902.11 and 902.13 is sufficient. 902.11 states that a party intending to offer business records into evidence under the code section shall, so no discretion, shall, make both the records and the declaration available for inspection, quote, sufficiently in advance of their offer into evidence to provide any adverse party, which would be the DA in this case, with a fair opportunity to challenge such record and declaration, contemporaneously providing the certificate of authenticity and the telephone records to the state after the close of evidence, and that's italicized, is not sufficiently advance notice to provide the state with a fair opportunity to challenge the records and the declaration. And then they cite a case and put in parentheses here, failure to comply with notice requirement excusable only because the business records themselves were provided in discovery well in advance of trial. So they're noting that something in this case wasn't exactly a parallel situation. They cite another case, Salas vs. JP Morgan Chase Bank, which is a Georgia case. Failure to comply with notice requirement only excusable because plaintiff received business records themselves as part of motion for summary judgment and had time to challenge records before filing their response. So they're citing case law here that's emphasizing that we didn't have a proper timeline to even challenge the authenticity of this data or the expertise of the expert witness. And there's cases here that agree with us. So rather than providing notice to the state at the time, oh, I missed a sentence. The court should not excuse Donald Trump's failure to comply with 902.11 when it is clear from the record that defendant Trump subpoenaed the records as early as February 9th, 2024, and had both the records and declaration in his possession by February 15th, rather than providing notice to the state at that time. He never provided notice and instead is now attempting to ambush the state with these unauthenticated records only 5 business days in advance of the scheduled closing arguments to deprive the state an opportunity to rebut. Now that's interesting because, we didn't get to really have a hearing, but I was seeing it reported last night and into this morning still. The biggest update available was just, hey, they're supposed to have a hearing on Monday. And then this news about the texts, the filings, comes out today also. So I'm wondering how locked in this 5 days away thing was. I feel like that might have been the tentative schedule from the beginning, but that might have gotten pushed back because when we closed out the week on Friday last week, there's this big question up in the air of, well, what is attorney-client privilege? Is there a reason that Terrence Bradley should or should not be able to divulge more than he's divulging on the stand? And then Judge Scott McAfee's like, I gotta meet with him separately, maybe. We gotta see what happens. And I hope to issue a decision on that by Friday next week, meaning today. Or it's now Saturday for me, so technically yesterday. But now here, the state is still acting like if they're filing this today, they're still expecting closing arguments to be scheduled 5 days from Friday. So I'm not sure what date they're relying on and how precise that is. But now they're going to argue the court should not now reopen the evidence, disregard its own standing order, and allow defendant Trump the opportunity to qualify Middlestat as an expert witness when it has declined to do the same in other cases. All parties coming before this court must be treated equally. Fair enough. You want to know what the problem is? The news has this. Like, it all went out. And I don't just mean like, hey, we have the documents because someone looked at the filings and pulled them. The news outlets are like talking about these text message timelines, and I know 12,000 or 9,000 interactions and late night conversations and leaving Nathan's house. Phone comes up 10:55 p.m. We're at Fani Willis's house till 4 a.m. Then we're leaving Fani Willis's house and going back home, and then sending a text message to Fani after arriving at home. All that stuff's in the news. So this filing, its goal is to accomplish making sure, however the rest of this hearing, this motion to disqualify Fani Willis, this motion is to keep her from being disqualified and to keep Nathan as special prosecutor in the case against Trump. It's only sealing it or asking for the judge not to consider it. So that way the judge can't use it in weighing his decision on key fact issues in this case. It's not going to seal anything that isn't already publicly known because the news has covered all of it. I mean, maybe there's like certain details that aren't covered, but do you get what I'm saying? Like, this is strictly to win this motion to disqualify. That's it. It's not to keep other information or data from getting out into the public. And then 3. We'll move on to argument 3. Actually, let me see what you guys are saying. And then, I see a bunch of Bradley mentioned. So Bradley can't be trusted. He was trying to slick, and now it's biting him in the arse. And that's like a huge lesson of this, right? Like, you can't trust. Not only was he like your friend or buddy that you got into business with, right? You knew him before you opened a business with him. So you had some type of relationship before that. And then you're also like, he's Nathan Wade's divorce attorney as well, but from the testimony about that, it was so unclear, it was so vague, it almost seemed like a buddy, you're my lawyer friend, and I don't want to, just be pro se in my own divorce, like, represent me, maybe I'll be doing the groundwork to write my arguments and do all my filings for my divorce case, but just help me out and, like, be the name on it or something. They were pretty vague about that. They didn't discuss retainer agreements or, I paid exactly this amount, signed a written retainer agreement with Terrence Bradley. It kind of just seemed like across the board, they were friends that Terrence Bradley just helped him out with a legal issue he was going through. And then he turns around and he's the one that calls up Ashley Merchant. Like, I got something to tell you about that Nathan Wade and Fani Willis. Isn't that to me, that's crazy, no matter which way you want to look at anything that's going on here. This is someone that decided, as an attorney who now is like, I could lose my bar license. He still called up someone else and said, hey, I've got information. Because everything on the record so far that we heard on Thursday and Friday, it was Terrence Bradley initiating this contact. But then he's worried about losing his license and divulging more than he should on the stand. After he called Michael Roman's attorney, or contacted her in some way, and said, I've got all the gossip. And Bradley's not the only Terrence Bradley out there. And then let's see. And yeah, Pam, so the testimony is going to be confusing because every other second he's like, oh, I can't say something. So he like wants to say something in one hand and then doesn't want to say something 2 seconds later. And then yes, so Tracker, that is the one that left the firm over an assault or harassment allegation. It sounded like it was more than one, right? Because they had the one other employee, the guy from the firm with the bun. He got up there and was like, yeah, there were some issues. And then they mentioned another name, but I don't think it was the same. It was like Ashley Rodriguez was one of them. But I feel like they were trying to get in that it was more than one issue, more than one accusation. And then they were called up to the bench, and then like they just kind of scattered and moved on. And then the dad takes a stand. So it was at least one accusation. And then Miranda says, seems like he was trying to get back at Wade. And now he's in the middle of a shit show because of his shady past came out despite his efforts. I mean, that's the way things go. Like, I feel like people you air out someone else's laundry and then your socks like stuck to your sweatshirt the whole time you're doing it. Like, and then he had to know that this would be high profile or televised. You know what I'm saying? Like, he contacted Ashley Merchant this January. Like, this was already a high profile, like, the Trump RICO in general. It's like the highest profile case going on in the country. And then he's just like, oh, maybe I can quietly snitch? No, there's no way. He just decided to be messy. And then Tracker says, anytime something's italicized, I can just feel the author's eyes rolling. And then Pam says, exactly. He's so busy trying to get back at Wade. His unscrupulous and deviant behaviors are coming out. It's his fault. He's really got nobody to blame but himself if he didn't want his stuff getting put on blast like that. And I know, Tracker's saying, why aren't more young people like me? I'm an old spirit. I retired early. I'm a New Yorker that moved to Florida. And then let's see. And Miranda, yeah, so, like, that is such a funny detail to me that the guy is like, hey, I was directed to look at these 2 nights, and one of the nights, when Nathan Wade's car gets back home, after being at Fani Willis's for, like, 4 or 5 hours or whatever, he arrives home. And then he sends a text message to Fani. So, let me know you got home safe, babe. And yeah, the proper summary is, don't shit where you eat. Now, where did I leave off? Somewhere over here. Okay, so argument 3, right? All right, cool. So if the court does determine that defendant Trump's inadmissible, untimely proposed supplemental Exhibit 38 can be considered, then the court must also consider the state's rebuttal evidence. So, Judge, if you're going to let this in, even though we're arguing it's inadmissible and it's untimely, so there's 2 reasons it shouldn't come in, if you're going to let it come in, then you need to give us time to come up with a rebuttal evidence, and we need to get our own expert witness in here, and he's going to need data, or she's going to need data, and they're going to need time to put all that together. So, notwithstanding the inadmissibility of defendant Trump's proposed supplemental Exhibit 38 under the court standing case management order for 701, pursuant this court's own evidentiary ruling against the state at the hearing, the phone records at issue are inadmissible. When the state attempted to impeach the testimony of defense witness Terrence Bradley, name him, concerning the circumstances surrounding his departure from Wayne Bradley Campbell firm, the court ruled that the state could not introduce extrinsic evidence contradictory to Bradley's testimony for the purpose of impeachment. So they're going to quote the judge here. Under Rule 608, I don't see how this isn't well beyond the core facts at issue. I think you confronted with him. I think he answered them as he saw fit. And argument can be made as a result. But to go down a whole mini trial on whether... So this judge does not want to stop the clock. But to go down a whole mini trial on whether he did or did not do this and the circumstances of his leaving the firm, I don't see how that gets past 608. So then they cite his YouTube channel and the timestamp. Imagine someone linking you to your judge, and someone files a motion linking you to your own YouTube channel to be like, this is what you said. Here, defendant Trump attempts to do the same exact thing. Introduce extrinsic evidence purportedly contradictory to Special Prosecutor Nathan Wade's testimony for the purpose of impeachment. If the court did not allow the state to impeach with extrinsic evidence, it cannot allow defendant Trump's attempt to do the same thing. All parties coming before this court must be treated equally. Now, this is interesting because you notice, hey, we tried to impeach Terrence Bradley, and you wouldn't let us do that. So why are you letting them come and impeach Nathan Wade? But they don't mention that this expert witness evidence, even though it's mostly relying on the geolocation for Nathan Wade's phone. We didn't really see any geolocation information, geo-tracking for Fani Davis in the other filing. We just saw that we know the outgoing messages. We know some information of activity involving Fani's number because we could see, Nathan's texting her or getting texts from her. But that information, nevertheless, isn't just going to be used to impeach Nathan Wade's testimony. It could also be used to impeach Fani Willis's own representation of when the relationship started, when it became personal and romantic. So I think it's actually really interesting, and not in a good way that they made it seem like the only use was to contradict Nathan Wade's testimony. I think they should have just been forthcoming about it and not tried to play like it didn't involve one of the actual parties in this hearing, because Nathan Wade's only a witness. This is a disqualification hearing for Fani. I don't know. Do you guys think it's interesting that they only worded it as Nathan Wade and not Nathan Wade and Fani? I think that was intentional, and I think that the judge would be kind of privy to that. But anyway, if the court did not allow the state to impeach with extrinsic evidence, it cannot allow defendant Trump's attempt to do the same thing. All parties coming before this court must be treated equally. Fair enough. But even if, in spite of all these evidentiary deficiencies, the court determines that it can still consider Donald Trump's proposed Exhibit 38, the phone records simply do not prove anything relevant. The records do nothing more than demonstrate that Special Prosecutor Wade's telephone was located somewhere within a densely populated, multiple-mile radius, where various residences, restaurants, bars, nightclubs, and other businesses are located. So it's a wide area. There's a ton of people here, so he could be seeing other people. He could be, you don't know who he's actually hanging out with just because his dot says he's here. That might not mean Fani's house. It could be someone that lives 2 blocks away from him. There's also all these places he could be going to and hanging out. So he's got reasons to be over there that are totally unrelated to Fani Willis and Yurdi's condo. Then they get all this emphasis. We have underline and bold text, people. This is double emphasis. The records do not prove in any way the content of the communications between Special Prosecutor Wade and District Attorney Willis. They do not prove that Special Prosecutor Wade was ever at any particular location or address. They do not prove that Special Prosecutor Wade and District Attorney Willis were ever in the same place during any of the times listed in Supplemental Exhibit 38. And, in fact, on multiple relevant dates and times, evidence clearly demonstrates that District Attorney Willis was elsewhere, including at work at the Fulton County District Attorney's Office, and this is capitalized, we have 3 emphases, and visiting the 3 crime scenes where a mass murder motivated by race and gender bias had taken place. They said, excuse me, he had reasons to be where he was, and you should know better because he was there for his work duties. And they attach Exhibit C. Calendars and emails showing District Attorney Willis at DA Wade's. So I think we might actually go look at that exhibit, but pin that because I don't want to start scrolling 40 pages and then get lost with where I was. But there are a ton of emails attached at the end. It's like all redacted, but they do have the to and from and the date and time that they were sent. So they must be trying to say, hey, you can't come at us for these dates because we were investigating that day. Argument 4. Defendant Trump's proposed Supplemental Exhibit 38, which is clearly inadmissible and has little evidentiary value, was not filed in good faith and is simply another attempt to garner media attention. And that I'm going to agree with across the board because this all came out, right away. The media had this. Like, I found articles on it and was able to pull up the document right away. Usually you kind of have like a gap in time where you can actually go and find, because I don't log into, I'm just looking for someone else to find the court documents, right? And then I'm downloading them. But the articles had them all linked. Easy peasy. So to me, at least for the defense's filing, I was like, the media wanted to coordinate this. And then shout out to AV. How are you, AV? If you ever want to join my stream, you are welcome. I will drop a link for you. And then I'm not sure. I think I saw Lee did a stream on this, but right now I'm looking at Fani Willis's, the DA's response to it, which I didn't see that many people talking about. And I think we should, because got to be fair, right? And then that's a good alibi. Yeah, and they underscored it 3 different times. We have the bold, we have the underline, and we have the all caps. That we were visiting 3 crime scenes where a mass murder motivated by race and gender bias had taken place. And you're sitting here trying to use this triangulation to suggest not just Fani, but also Nathan Wade are lying, and you're trying to impeach them with it. So, the state submits that defendant Trump's proposed Supplemental Exhibit 38 was not filed in good faith, but instead is nothing more than another attempt to garner salacious headlines in the media. And guys, I'm just going to agree with that. Like, it's such a high-profile case that there's, like, the judge has to be considering what this could look like and what this would mean for the rest of the case against Donald J. Trump, who still, when he can, President Donald Trump, he still wants to run for office again. And the judge has to decide, look, I've got to protect the integrity of this overall trial that's supposed to take place. And I don't know. Do you guys think it's impactful if the general public thinks the way we made a little joke in here, like, all right, Fani knew to kick him out at 3:55 a.m. Like, that's like, if you look on X and search up this topic, everyone's saying like, oh, there was a booty call, they got the text messages. It's just such a huge bad look for such an important case that I think that puts a lot of weight on Judge Scott McAfee's shoulders to decide if something's relevant or not. Whether something, according to this filing, is of little evidentiary value. It's still important if the public thinks or perceives that the person trying one of the most important trials out here was having booty calls and then lied about it. The perception matters here. But again, the judge is the finder of fact, so we will see. And then the New York Post article. So they're going to pull in these articles to show us. And of course, they're citing the New York Post. Some of these headlines, including the attached, were patently false, and many others were misleading. roughly simultaneous with the filing. So that's what I'm telling you. This came out. This was all at the same time. This was in somebody's hands, ready to fire off into the press. So simultaneous with the filing, counsel for defendant Trump immediately provided unredacted cell phone records, which contained personal identifying information belonging to Special Prosecutor Wade and District Attorney Willis to members of the media. Uh-oh. So they attached this exhibit. Portions of defendant Trump's proposed supplemental exhibit 38, including cell phone records with personal identifying information, were then quickly distributed on social media. What? So that's, okay, so that's why we got, was there personal information in that? Did they leave the numbers in there? Hold on, that was that heat map, right? Let's go to Exhibit F, guys. Okay, yeah, and you have, this is the New York Post exhibit that they're citing. So the headline is Nathan Wade's phone pinged at Fani Willis's home 35 times before they claim affair began. Yeah, so, and that's the thing, right? Like, people will read this headline and they'll stop here. And, I mean, we didn't really see that number pulled forth in the defense's motion even, right? He's like, yeah, there were 2 nights, there were a bunch of interactions between them. There was like one night and then another night where he shows up at a weird hour and then leaves at a weird hour. But here, the headline from New York Post is 35 times before they claim affair began. This is a juicy, salacious headline. And we didn't even see the filing highlight this 35 number. But that's the New York Post for you. Let's look at this other exhibit because I want to see. So they're saying that this contained personal information. And I know it's going to be a pain in the butt to try to zoom in. And maybe it has his phone number. I guess I shouldn't really like zoom in and pull it up that much. Between Wade, AT&T, there's a date range. I see a case number, but I don't see a phone number unless it's this tiny, tiny text at the bottom under all the cells. So that's blurry to me. I can't actually see. But according to this filing, they're saying that this tweet that went out, that exhibit, there's personal information in there that's not supposed to be available. But the defense sent over an email and coordinated with the media, and somehow it got on social media, personal information. So I can't see it, unfortunately. Maybe we can go look at that tweet itself and without it being blurry and see. But, you know. And then where were we? We're talking about Exhibit F. Okay, so there is a footnote. So Attorney Sato's contact information has been redacted from this exhibit at the direction of District Attorney Willis to protect his safety, a courtesy she was not provided. You know I love a good footnote. So defendant Trump's proposed supplemental exhibit 38 includes an attempt to introduce evidence by affidavit, even though defendant Trump insisted that the state was disallowed from doing so and compelled Special Prosecutor Wade to testify. Defendant Trump's proposed supplemental exhibit 38 fails to comply. And again, they can say that, right? But we can't say that about Fani because Fani wanted to go testify. No matter what the catalyst was that she decided, I need to get up here because I'm being lied about. You know, they can't really make an argument that, hey, you're trying to introduce this now, but you insisted that the state was disallowed from doing so and even compelled Wade to testify. They can't make that same complaint about Fani because she just went up and said, hey, I'm here. Defendant Trump's proposed supplemental exhibit 38 fails to comply with the court's standing order and evidentiary rules regarding notice or qualification of expert witnesses. Moreover, the state questions whether defendant Trump legally obtained cell site location information, which is generally only obtainable after a finding of probable cause and issuance of a search warrant. So they're saying, we don't even know if you had the proper means. You didn't have a warrant. We don't even know. You haven't shown us a warrant. Where is it? Did you even get this legally? So, and that could be an issue for sure. For all these reasons, it is clear that defendant Trump's proposed supplemental exhibit 38 is inadmissible, was not filed in good faith, and should not be considered by the court. For the reasons set forth below, the court must exclude defendant Trump's inadmissible proposed supplemental exhibit 38 from consideration. Respectfully submitted on this day, the 23rd day of February 2024. So, they do have a bunch of, they're putting in here the case management order. They're saying, Judge, this is how it's supposed to go. and the defense did not follow your own standing orders for bringing this in. And then a lot of these other exhibits, let me show you, like this is the calendar, the emails, you see it's mostly redacted, but I don't think it matters. The point is, you know, here's certain dates, right? So here's one email, it's August 3rd. Here's another one, it's August 23rd. Here's another one, it's August 23rd. And then let's see, we have a calendar. What day are we on? April 12th. All right, let's go to the August ones. Do we get an August calendar? Hold on, wait a minute. Am I not? So they're saying that these emails and the calendar are attached to show they had a certain place to be on a certain day. And maybe I'm not reading something right, but the subject says 8/2, so August 2, 21, August 3rd, 2021, August, but then the calendar's for April. I feel like I'm either having a slow moment or I'm like missing something. We have one for June 30th. November 17th. Okay, so that's closer to... Do we have more calendar pictures anywhere? November. October 7th. Okay, I would go, if I was them, I'd be like, see, this is why you should understand that they didn't follow the right standing order for introducing this type of stuff, because we didn't have time for a proper response. Because look at the, we're telling you that we have emails and courts and their calendar dates lining up, and we've attached them here where we had some type of work obligation. We were looking at this case, we were at the murder scene, and to me, unless I'm missing it, the email dates don't match the two calendar slides. They're showing us April and May. So maybe they're not supposed to tie together, but I don't know. We have a spa massacre victims update in the DA conference room, which is not to be scheduled at a scene, unless maybe Fani was supposed to be in the conference room and Wade was out in the field. I don't know. This is a smaller screen for you guys, and I'm obviously like controlling the mouse, but I feel like I'm missing how this is supposed to tell me you guys were boots on the ground at a crime scene on specific dates based on the emails and the calendars, when the emails and calendars don't even tie into the same times. I feel like they messed up putting this part together, but they are saying that they were rushed, so kind of goes to their argument there. For the other exhibits, again, this is linked in the description. The link should be correct now, so you can open up both filings. You could check out that New York Post article if you want. And this is the email from attorney Steve Sadow. So he says, is this the first one? So he says, and this is dated today at 4:17 p.m. I guess it's safe to assume Eastern time zone. So not too long ago. I inadvertently sent the unredacted cell phone records to Bill Rankin this morning. When I realized the error, I immediately contacted him and told him explicitly not to disclose them to anyone else and not to publish the cell phone numbers or any other protected information. Mr. Rankin indicated he understood and would not publish the cell phone records or address. It was my mistake alone. So who's Bill? Let me see. Should I know that name? Oh, from the Atlanta Journal. So that's from this company. This news art. Let's see. Did Bill write this? Yeah, okay. Here we go. That's Bill Rankin. I wonder if we have an update in here that he had to go and remove anything. No notice of an update. Okay, updated 2 hours ago. So maybe the update was for something else. Maybe they had to go back and change something at some point because something was published that shouldn't have been in there. Yeah, never an email I imagine you want to send like, oops, we made an oopsie. Please don't make it an even bigger oopsie. But yeah, I say let's leave it at that then with if you guys want to look at these exhibits, everything that's in the end of this filing, that way it's full size on your screen. The links are going to be in the description there. And then Miranda, yep, it's headlines over substance. And then, hey, Mr. Minutes. I feel like I'm up really late today. And then Tracker says, remember the coverage they did on Jonathan Majors? The New York Post is a rag. Honestly, when I open up New York Post, it's one of those sites that just seems to have a lot of ads, or you think there's a video that's related to what you're reading. And it's just another weird story about, like, I don't know. New York Post has a lot of rabbit holes about stuff that isn't even news. I was scared to rely on it. I used it as, when I was looking at the NYCHA case, so the New York City Housing Authority, there was like that big DOJ bust, like biggest on record for a bust of, bribery for government employees, because it was housing authority employees taking kickbacks from contractors. Because New York Post is like not just in New York, but they really like going after that type of thing. Unfortunately, they had the highest quantity of reporting about New York City Housing Authority issues. And the whole time I was preparing to do that video, I was like, oh my God, you're like trying to read an article on the New York Post, and it's like, lady lets snake run wild in apartment and 7 people get bit. And it's just like all the stories on there are just crazy. They're so clickbaity. But yeah, so they made sure, the DA here made sure, hey, we're going to call out clickbait, and we're going to specifically use a New York Post article to show it. And I really think we didn't see this number highlighted in the actual motion, the thing that's being used as the core argument to the judge. We didn't see Charles, I keep forgetting his last name, Charles Middlestat. We didn't see him go 35 times in that filing. But New York Post is underscoring something that the defense, that Trump's attorney, isn't even underscoring in their argument to the court. So that's New York Post for you. And then it's a Rupert Murdoch paper. Well, that adds up. I'm going to close this because I didn't plan to do a stream, but I saw a lot of people talking about the text, and I didn't see a lot of people talking about the filing and response. And I thought it was important to get some conversation going about the response that was filed. That doesn't mean I'm saying that one has merit and the other doesn't. It's not my decision to make anyway. But again, if we have headlines like this huge big bombshell, like Nathan Wade's phone pinged at Fani Willis's home 35 times before they claim the affair began. Well, it's important to say that the other side is saying this data isn't precise. It's not really pinpointing he was at any specific address any of these times. All right, now we got to weigh what we've got on both sides and see what we can come up with. So thank you guys for tuning in. Next update we'll have on this is, I guess there's supposed to be something going on Monday. So who knows? It never ends with one thing, right? And then, yeah, you're saying don't depend on... I think that's a common sentiment. And you're saying right wing here. But I do think it's one of those papers that most people, right, even leaning into the opposite side of the spectrum, it's something that a lot of people are like, it's going to be gossipy. Everybody kind of has this idea that when you go into something with the New York Post, no matter, even if you are on the right side a little bit, it's still the New York Post, right? It's like one of those kind of like universal things. But yeah, I don't know. Sometimes I hate when I Google search something and the only results I'm getting are an outlet I don't want to rely on. And Miranda, yeah, so I don't know. The dates on her calendar and emails don't line up. I feel like it's possible that it was just the wrong things were put in the exhibit there. Or maybe we're just not getting enough of an explanation of how one's supposed to follow the other. But it was underscored. It was super underlined that we had a specific other reason, not just because there's other businesses or a lot of people here and you can't even pinpoint the exact address. But Nathan Wade had other reasons to be in those areas, and specifically he had to be there for work. I feel like there's at least something close to that area that this triangulation encompassed, this geofence encompassed, that he may have had to do over there, and I'm sure they're going to produce the record if it was incorrect in this filing. And I guess we'll see that on Monday. So if there's any updates, I don't think I'll do a stream on this type of, like, an update on Monday. There's so many other, especially attorneys, that are covering the live stream of any of these hearings, and I'll probably be in those chats watching it. I just really wanted to bring some attention to both of the filings instead of just seeing all the attention on one only. What would you do if you were Judge Scott McAfee? What would you... Do you think that this... You want to hear both sides? You want to hear supposed non-expert, but really an expert witness, and also a rebuttal? You want to hear all of it? You just want to not hear it at all? Would you take this data in and say, no, you don't have time for a rebuttal witness? I think Scott McAfee wants to move this along, personally. So I don't know. I guess we'll see. And then New York, there's a lot of New Yorkers. New York Post is biased. Yeah, you guys do not like the New York Post. I don't either. So I was happy to get some Jonathan Majors coverage, but every time I had to get a detail from New York Post, I would like flip to another site and hope I could get it somewhere else or get it from someone on Twitter, but that case just sucked to cover. And then no problem at all. You guys leave your thoughts in the comments or at the end of the chat as we tune out, and we will have another stream some other time. Take care.